Hello, everybody. My name is Chris Manning, and this is the Liberty's Last Refuge podcast. And boy, did we have some news this week. We're going to go over first the Supreme Court briefing in the Donald Trump versus the Colorado Supreme Court case. That's the case where the state of Colorado had ruled that former President Trump, is ineligible to appear on the ballot because he engaged in an insurrection, and therefore he's disqualified under Article 3 of the 14th Amendment. There were some very interesting arguments from the justices, some of which I was frankly surprised at. I'm going to play some of those, some of the recordings from the arguments. Obviously, there are no cameras that are allowed, but there is this great little site called SCOTUS Tunes on Twitter. And the creator of this Twitter page has, in essence, taken little cartoon images of each of the Supreme Court justices and the attorneys as they are arguing, and puts the audio to their little cartoon characters. So I actually enjoy it. I think it's interesting. So I'm going to play a little bit of that for you guys. And then we're going to talk about the disastrous press briefing that President Biden had after special counsel report came out in his classified documents case. So those are the things we're going to get into on today's episode. All right, so the first thing is the Supreme Court case and some of the arguments that were made. Now, as I have, if you follow me on Twitter, you've seen me argue this position that there was zero chance that Donald Trump was going to have this disqualification under the 14th Amendment upheld under review. Now, Colorado did something that every other state has rejected. There is this legal group that has been trying to push this bogus legal theory that Donald Trump engaged in an insurrection, therefore he is automatically disqualified from running for office again. This argument falls flat on its face if you just bother to read the actual text of the 14th Amendment. I believe I've gone over that prior, so I don't think we'll go into that in great detail. But basically the argument that the state of Colorado, not the Colorado Supreme Court, but the litigants who brought this case in the Colorado Supreme Court argue that the disqualification is self-executing, that all of a sudden, just because some political group has made the claim that you've engaged in insurrection, that then makes it automatic and you can't run for president. I think that self-executing argument gets absolutely destroyed under questioning. But also one of the things that I thought was the most obvious was the fact that the President of the United States is not an office that is listed. And surprising to me, it was Ketanji Brown Jackson who makes that argument for the textualist argument that the President of the United States is not an office that is listed as one of the offices that can be prevented under the 14th Amendment. And so I think she's actually going to take the textualist argument, and it is possible that this comes out a 9-0 or possibly an 8-1. Never know with Sotomayor. She wasn't the most skeptical, I'd say, of the arguments made by the group that was arguing that Donald Trump should be kicked off the ballot. So let's go ahead and listen to Ketanji Brown Jackson's argument here when she is questioning the attorney representing Donald Trump.
Presidency is one of the barred offices. I guess I'm a little surprised at your response to Justice Kagan, because I thought that the history of the 14th Amendment actually provides the reason for why the presidency may not be included. And by that I mean, I didn't see any evidence that the presidency was top of mind for the framers when they were drafting Section 3, because they were actually dealing with a different issue. The pressing concern, at least as I see the historical record, was actually what was going on at lower levels of the government. The possible infiltration and embedding of insurrectionists into the state government apparatus, and the real risk that former Confederates might return to power in the South via state-level elections, either in local offices or as representatives of the states in Congress. And that's a very different lens. If your concern is trying to make sure that these people don't come back through the state apparatus and control the government in that direction, seems to me very different than the worry that an insurrectionist will seize control of the entire national government through the presidency. And so I just am surprised that you would, given the text of the provision and the historical context that seems to demonstrate that their concern or their focus was not about the presidency, I just don't understand why you're giving that argument up.
There is some evidence to suggest that, Justice.
Is there any evidence to suggest that the presidency was what they were focused on?
There is some evidence of that. There were people saying we don't want Jefferson Davis to be elected president, and there was also one of the drafts of Section 3 specifically mentioned the presidency and the vice presidency.
But it wasn't the final.
It wasn't the final.
So
It wasn't. Yes,
right.
I'm sorry. It wasn't the final enactment, but it does show that there was some concern by some people about Confederate insurrectionists ascending to the presidency. And we didn't want to make a law office history type argument where we just look at the historical evidence and pick the evidence that we like and interpret it tendentiously, because the other side can get back with us and throw this countervailing evidence back in our face. So we wanted to focus more on the text of the Constitution, because this was ultimately a compromise provision that was enacted in Section 3.
All right, let me ask you another question about the states, because you have forcefully made an argument about the states not being able to enforce Section 3. So if we agree with you on that, what happens next? I mean, I thought you also wanted us to end the litigation. So is there a possibility that this case continues in federal court if that's our conclusion?
I don't see how it could unless Congress were to enact a statute in response to this court's decision.
So your point is that we would have to say congressional enacting legislation is necessary for either state or federal enforcement.
That's correct.
So there, I think it shows that Ketanji Jackson Brown is fairly skeptical of the idea that the president can be excluded under the 14th Amendment. When the other attorney's up, she's a little bit more pointed on that, and she points out and asks him, well, if they wanted to exclude the president and he falls under the office, why is he not there? And of course, the attorney then argues that, well, he falls under the other officers, and clearly that's ambiguous, and she asks him about whether or not that is ambiguous or not. And if that's the case, well, then wouldn't it go to the defendant? In this case, the Trump would rule. And I don't think that the attorney representing the plaintiffs in that case had a very good argument against it. He gets pretty eviscerated, especially when it comes to the self-executing argument. And I'll show that briefly as well.
You say he's disqualified from the moment it happens. Now, I understand the de facto officer doctrine might be used to prohibit people from seeking judicial remedies for decisions that take place after the date he was disqualified. But if he is in fact disqualified from that moment, why would anybody have to obey a direction from him?
Well, ultimately, there still has to be some kind of procedure in place to adjudicate the disqualification. Certainly, Congress could impeach a sitting president, but that's the only remedy I'm aware of that exists for removal or otherwise negating the authority of a sitting president.
Why? On what theory? Because the Section 3 speaks about disqualification from holding office. You say he is disqualified from holding office from the moment it happens.
Correct, but nevertheless...
So it operates, you say that there's no legislation necessary. I thought that was the whole theory of your case. And no procedure necessary. It happens automatically.
Well, certainly you need a procedure in order to have any remedy to enforce the disqualification, which is different.
That's a whole separate question. That's the de facto doctrine. It doesn't work here. Okay, put that aside. He's disqualified from the moment, self-executing, done. And I would think that a person who would receive a direction from that person, the president, former president in your view, would be free to act as he or she wishes without regard to that individual.
I don't think so, because I think, again, the de facto officer doctrine would nevertheless come into play to say this is...
No, de facto, that doesn't work, Mr. Murray, because de facto officer is to ratify the conduct that's done afterwards and insulate it from judicial review. Put that aside. I'm not going to say it again. Put it aside, okay? I think Justice Alito's asking a very different question, a more pointed one, and more difficult one for you, I understand, but I think it deserves an answer. On your theory, would anything compel a lower official to obey an order from, in your view, the former president?
I'm imagining a situation where, for example, a former president was, a president was elected and they were 25 and they were ineligible to hold office, but nevertheless they were put into that office.
No, we're talking about Section 3. Please don't change the hypothetical, okay? Please don't change the hypothetical. I know I like doing it too, but please don't do it, okay?
Well, the point I'm trying to make is
he's disqualified from the moment he committed an insurrection, whoever it is, whichever party, that happens. Boom. It happened. What would compel, I'm not going to say it again, so just try and answer the question. If you don't have an answer, fair enough, we'll move on. What would compel a lower official to obey an order from that individual?
Because ultimately we have statutes and rules requiring chains of command. The person is in the office, and even if they don't have the authority to hold the office, the only way to get someone out of the office of the presidency is impeachment. And so I think if you interpreted Section 3 in light of other provisions in the Constitution like impeachment, while they hold office, impeachment's the only way to validate that they don't have the ability to hold that office and should be removed.
Mr. Murray, can I just ask you about something Justice Kagan brought up earlier, which is the concern about uniformity and the lack thereof if states are permitted to enforce Section 3 in presidential elections. And I guess I didn't really understand your argument or your response to her about that.
Well, certainly if Congress is concerned about uniformity, they can provide for legislation and they can preempt state legislation.
Yes, but you say that's not necessary.
But it's not necessary. In the absence of federal enforcement legislation, these questions come up to this court in the same way that other federal questions come up to this court, which is that a state adjudicates them. If the state hasn't provided sufficient process to comport with due process, a notice, and opportunity to be heard, one can make those challenges. But assuming, as here, we have a full evidentiary record, an opportunity to present evidence.
So I understand that we could resolve it so that we have a uniform ultimate ruling on it. I guess my question is why the framers would have designed a system that could result in interim disuniformity in this way, where we have elections pending and different states suddenly saying you're eligible, you're not, on the basis of this kind of thing.
Well, what they were concerned most about was ensuring that insurrectionists and rebels don't hold office. And so once one understands the sort of imperative that they had to ensure that oath breakers wouldn't take office, it would be a little bit odd to say that states can't enforce it, that only the federal government can enforce it, and that Congress can essentially rip the heart out of Section 3 by a simple majority just by failing to pass enforcement legislation. Federalism creates redundancy. And here, the fact that states have the ability to enforce it as well, absent federal preemption, provides an additional layer of safeguards around what really Section 3...
Yeah, and I'll ask you about the history when I get a chance again.
So in that segment there, I think Justice Gorsuch eviscerates the argument about it self-executing. As you can see, the point that Justice Gorsuch is making, well, if you're saying that at the point of this insurrection occurring, he's no longer eligible to hold office, but you're saying that there is no legislation from Congress necessary in order to adjudicate that, to make that known, to make that official. Well, think if the insurrection had happened while there were still 2 years left in this person's administration, then if Congress has taken no action to say that they're either being impeached or that you've got 2 years of this supposed illegitimate person who's still in office. And this is where the argument of a self-executing amendment, a self-executing provision of the 14th Amendment, Article 3, falls flat on its face right there. And you see he doesn't have a good argument. He's simply saying, he admits that, well, then Congress would have to take action. Well, yeah, that's the entire point, is a couple voters in Colorado don't have the authority or the ability to say that an insurrection occurred. That is up to Congress. Congress has to make the point in it. And there's a little bit of a history there saying that after the 14th Amendment was passed, and you had the court case basically saying that this provision is not self-executing. Congress passed legislation in 1870 making sure that they they understood the court to say, well, yeah, that's probably a good argument. It can't be self-executing. We need to pass legislation. So Congress did in 1870. So I think right there that kind of blows up the argument. And then also you see Ketanji Brown Jackson again pointing out that, well, if Colorado is saying that this person is eligible, but 38 states or 42 states disagree with you, well, now we've got this disunity, and who is on the ballot in different states obviously is going to jeopardize the election for the president of the United States. And if that's the case, how is it possible that we think that the framers of the 14th Amendment gave the states the individual right to make a determination on their own of who is eligible under the 14th Amendment? So I think this is going to be, at a minimum, it's going to be an 8-1 decision. I would not be surprised if this is unanimous. Donald Trump will be on the ballot, and this will be over. Unfortunately, when you came with such a weak argument, a legal argument that, in essence, Colorado was relying on the fact their entire goal was not that they had strong legislation to back them, not that they had the facts to back them, but they just hoped that they could get an argument won in court. And you kind of see that during that exchange where they're asking, well, how is this going to happen? And the attorney for Colorado defendant or the applicants are like, well, you guys could make that decision. And so you see that was the entire point of their case, is they were just judge shopping for getting a ruling in their favor. Now, they failed in like 13 other states. They tried this in multiple states where they thought they would have a receptive judiciary, and they failed. And their entire goal was get to the Supreme Court, and they thought that they could win the argument here. And the attorney is clearly not going to win this. It's not even going to be close. All right. So that is the Donald Trump case. Now let's talk about the special counsel report that came out on President Joe Biden's handling of classified documents and his absolute disaster of a press conference that he had afterward, trying to defend himself, where obviously in the special counsel report, it makes some very strong statements about the president's mental faculties. All right, so here is the special counsel report, and this is just the summary. I'm going to just briefly go over that. And so the very first thing that they say is, we conclude that there's going to be no criminal charges. Now, obviously, the president of the United States, if you're actually following the guidelines and you're not just throwing them out because the person has the letter next to their name that you like, whether it's an R or a D, and you change how you think enforcement should be based on the letter next to their name, obviously a sitting president can't be charged for these sort of things. Now, the Court of Appeals kind of threw that into jeopardy, saying, oh yeah, the president can be, in the Donald Trump case about his immunity clause, they said that a president can be charged for criminal acts while he's in office. So that's kind of dangerous to Biden if you actually take that to its logical conclusion. But regardless of that, a sitting president can be charged. You can charge them afterwards, certainly after they've left office, for criminal acts that they committed while they were president of the United States. Now, they're not going to charge him. Obviously, Department of Justice guidelines preclude the sitting president from being charged with criminal acts until he's been impeached. Now, the investigation uncovered evidence that President Biden willfully retained and disclosed classified materials after his vice presidency when he was a private citizen. This included marked classified information about military and foreign policy in Afghanistan and notebooks containing Mr. Biden's handwritten entries about issues of national security and foreign policy implicating sensitive intelligence sources and methods. So these are documents that President Biden had in his home, in his garage, and in his filing cabinet, of documents that were marked classified. Now, of course, when Joe Biden gives his press conference, he tries to lie and say that this wasn't happened. There was nothing that was actually marked classified, and he didn't share them. Well, not only did his ghostwriter refute that in the investigation with the special counsel's office, but also there were recordings where Joe Biden, in essence, says, hey, hold on, I just found the classified stuff. It's downstairs. Let me go look at it. And so he knew at the time. Now, what I'm kind of surprised at is after the special counsel investigation was announced, Joe Biden's ghostwriter deleted some of those recordings in order to protect Joe Biden from having evidence showing that he knew that he was revealing classified information to his ghostwriter. And I'm actually surprised that they didn't bring up obstruction charges. Now, of course, this kind of plays into the Republicans' narrative that there is a two-tier justice system where Mr. Nada for President Trump, who was his aide, who moved the boxes, right? He didn't destroy evidence. He moved the boxes from one location to another, and I guess the government's argument is that he did that so that way they would not be found during the during the FBI search. That's the theory of their argument. Well, Joe Biden's speechwriter actually deleted evidence that could implicate Joe Biden in that he knowingly disclosed classified information to his ghostwriter. So those who are arguing that Donald Trump revealed nuclear submarine secrets to the Australian billionaire, well, Joe Biden revealed the secrets to his ghostwriter. Again, in one case, former President Trump is being charged, whereas President Biden and his ghostwriter are not. But then also in this case, the report is pretty damning regarding President Biden's mental capacity. In it, they basically say that another reason why they wouldn't bring charges is because they believe he's a senile old man and he would present that way at trial where they might not be able to convince a jury that he was cognizant enough of his actions, even in 2017, to get the necessary state of mind required for their conviction in their mind. Now, obviously, that differs. Whenever it's President Trump, they argue, well, intent doesn't actually matter. It's just the fact that you held the documents and you willfully retained them. But when it comes to Biden, they want to make the argument that his mental state has to be proved. They also state that President Biden couldn't remember within several years of the year that his son Beau died during their interview. It also stated that he wasn't sure when he left office of the vice presidency. And now that part where he doesn't know where Beau died, right? He takes exception to this at the press conference. And he wants to prove that, yes, he does in fact know when Beau died. But then he blows himself up. During his discussion of this, and this is the first clip I'm going to show you, he's talking about the rosary that he has worn since Beau died, and he's talking about the church where he got the rosary, and he forgets what the name of the church is where he got the rosary, and I'm going to show you that.
The report of the special counsel found the exact opposite. Here's what he wrote. There is in fact a shortage of evidence that I willfully retained classified materials related to Afghanistan. On page 12, the special counsel also wrote, for another documents, the decision to decline criminal charges was straightforward. The evidence suggests that Mr. Biden did not willfully retain these documents. The evidence said I did not willfully retain these documents. In addition, I know there's some attention paid to some language in the report about my recollection of events. There's even reference that I don't remember when my son died. How in the hell dare he raise that? Frankly, when I was asked the question, I thought to myself, it wasn't any of their damn business. Let me tell you something. Some of you have commented, I wear since the day he died, every single day, the rosary he got from Our Lady of... Every Memorial Day we hold a service, remember.
So you see right there, he loses his train of thought, and he's pointing to and showing the rosary, but he can't remember the name of the church. And so he just blanks there for several seconds where there's silence. And so he's trying to make the case that he's mentally competent. And there he goes, he can't remember the name of the church. Now, he's done prior interviews of this. It was the Lady of Guadalupe in Mexico is where he got the rosary. But here, during his press conference, he can't remember that. Now, after the report, why the Biden administration is so terrified about this report is because it says what everybody already knows and what everybody who is a supporter of President Biden has been trying to hide, that Joe Biden is definitely lost his mental capability to be president of the United States. And this report and unfortunately this interview, this press conference where he tries to defend himself and he blows himself up even worse, that he is not mentally there anymore. And I would not be surprised if the 25th Amendment is invoked, and that is where you remove the President of the United States because they are no longer capable of doing their job. So I think as time goes on and there will be more slips, the White House is going to have to do one of two things. Either they're going to have to bury Joe Biden in the closet and not allow him to speak to reporters again, or they're going to have to put him out there. And the more you put him out there, the more obvious it is going to be to people that the President of the United States is no longer mentally there. So that's what we had this week in news, kind of a lot going on. I know this is a little bit longer video than I normally do. And go and check out the SCOTUS tunes. I'm going to go ahead and put the link to the Twitter account of that individual who does that. I hope they don't mind me showing that. I really like his page. I find it a lot more interesting to listen to Supreme Court briefs when you've got the little animation. It makes it a little bit more interesting. So that is this week's episode. Once again, my name is Chris Manning. This is the Liberty's Last Refuge. If you like this video, please share it, like, comment. I'm trying to do my best to keep on this weekly schedule for right now. Sometimes I get a little bit behind like today, but hope you all have a wonderful weekend. Bye.